afternoon, everyone. I hope everyone's enjoying the last couple days of August. I can't believe September is next week. Where did the summer go? Welcome to our August webinar. Today we have attorney Cathleen Summers joining us, and she will be talking about your estate planning for your family's second home. Attorney Summers, would you like to take it away?
Allie, thank you so much. I appreciate it, and welcome everybody. I'm going to be talking today about planning for a second home. And well, a lot of this presentation really is focused on something like a vacation home. This type of planning can really be for any type of second home. And we'll talk a little bit more about that and why planning for second homes is so critical in order to be able to ensure that they successfully pass on to the next generation, particularly if it's a kind of home that you want to keep within the family, or at least hope to have kept within the family for years to come. So let's just begin by talking a little bit about second homes and, people, why they buy second homes, etc. Second homes really are, for just, I'm sorry, I'm opening up screens that I didn't mean to, I apologize. For things like personal gratification, of owning a second home. Some people want them for reasons of tax purposes. Oh goodness, they keep having screens pop up. For tax benefits, like being able to have mortgage or interest deductions on their annual tax returns, real estate tax deductions. Creating equity in a second home might be another way. Instead of renting on a regular basis, if you own the property, you might be able to create a level of equity in that home. So if and when it is sold at some point, or you need to use some value from that property during your life, you have access to that equity value. Possibly income streams. Second homes are certainly something that can be rented out, whether it be something that you do on a seasonal basis or whether you do it on an annual basis. It might be something that helps to supplement your income stream. Independence, pride of ownership, being able to plant roots, those kinds of things. The reasons to have a second home are as varied as the type of second homes that there are. But there are also cons to owning a second home. Things like, the cost of owning a second home, having to worry about that home while you are not there. It's security, it's safety. I happen to own a second home myself, and my poor husband found himself last week for the first time in the many years that we've owned it, having to rush up there because we received a notification that there was a fire alarm going off in the house. Thankfully, nothing was happening, but 2:30 in the morning, it's not the type of call you want to receive. The cost of having a second home is also a con. You do have things like additional property taxes and possibly a mortgage on that property, whether you're going to keep that property with utilities going 12 months out of the year, particularly in the Northeast here. How are you going to make sure that that property is heated during the winter months? So having a second home can be incredibly enjoyable, but it also can have cons, and you really need to think about that when you're making a determination about whether you do want to own a second home, and particularly something like a vacation home that you might not be using all the time. So where we always tell people to begin when they're thinking about how to plan for the second home is always at the end. I always joke a little bit that second homes work really well when the initial owners, usually the parents or the older statesmen in a family, own that property. They're the ones who are making all the decisions about the property, who gets to use it when. Oftentimes they're carrying a lot of costs associated with the property, the maintenance, the things like property taxes and mortgage, insurance costs, all of those types of things. And it works out really well when that first generation is making the decision. Where things get more dicey is if this property is something that you want to pass on through the generations. Then after, the elder statesmen of the family are gone and no longer in control of the property, how are you going to make sure that the next generation is able to keep this going and able to do so without ruining relationships? And we're going to talk a lot more about that, because that's one of the biggest issues we see with something like a second home that's being passed on through the generations, is that it can get very, very complicated as more owners begin to have an interest in the property. People's interests overall in utilizing the property may be very, very different. And so you want to think about that while the original owners, or, really what I look at is that original generation of individuals are still around and still able to be able to exert some control over how this property is going to flow in the future. So we look at these properties, we call them heirloom properties, and I'm going to talk a little bit about what is an heirloom property, but the truth is it's any property that you may have. It may be the home that you inherited from your grandparents or your parents, and you now want to make sure that this is going on to the next generation. It may be that second home down on the Cape or over in or up in New Hampshire, whatever, in order to be able to make sure that that property again is able to pass on without any issue. And something to think about with these second properties, unlike, oftentimes our primary property, there is a certain level of risk with the property that comes of it being unprotected. If you need nursing home care in the future, if you end up with, any kind of creditor issues, even divorce issues with, let's say, your children, et cetera, these properties can be subject to exposure, where oftentimes our primary homes have a certain level of built-in to them in terms of protection. And so we want to talk about how we might be able to look to protect that. So one of the big questions we often start with is, do you have an heirloom property? And again, as I said, an heirloom property has a very, very wide definition. It really is any property that you believe is worth protecting and preserving through some kind of level of special planning. And whether that is, a property, again, up in a lake in New Hampshire or on the seashore down on the Cape, or that rental property that you inherited from your own parents or you bought during your lifetime that might be, in one of the cities and it's creating income for you. Any of these things may be viewed as an heirloom property, something that you want to ensure is being protected and that there is some kind of plan around how that property is going to pass to the next generation of beneficiaries and be controlled and utilized by that next generation. So some examples again, your current residency could be your heirloom property. Again, this is the property that you want to make sure is going to pass on to the next generation. The beach house, country cottage, the lake home, the mountain cabin, the ski chalet, the condominium, farms, ranches, and again, rental property that you may own. It's a very wide range of examples of what might be considered to be an heirloom property. So why do you want to look to save the home? And these are some things that you want to think about. And I'm going to talk about both the pros and the cons. Certainly, oftentimes when we think about a vacation home or an heirloom property, it might be the place that the family gathers. It might be the place where, the kids or your loved ones are all over the country, but they come back to this home on a regular basis. It's a place where memories are made. It's your reliable vacation spot, the place where you are able to enjoy with friends and family. And it's something that you really have, put a lot of your own, not only maybe money into, but, emotional aspect of things as well in terms of how you value this property. There's a saying that I hear all the time, which is they're not making any more shoreline. So, oftentimes people have bought a home and they're, these homes are increasing in value over the years and they want to keep them in the family or keep them somehow within their level of beneficial interest. So keeping these properties in a way in which you can ensure that they pass on. But we're also going to talk about some of the downsides too, because, one of the reasons that we look to do this kind of planning is that, again, while the original owners of that property or the original kind of statesmen who have the property are able to make all the decisions about the property and manage all of that themselves, when the next generation oftentimes steps up to own the property, we find that their lives may be in very different places. You've got the child who lives across the country and isn't able to get back to the home on a regular basis. What happens to their interest in that property as opposed to the child who lives maybe locally and uses the property all the time? So we'll talk a little bit about that too and how this kind of planning is really meant to address those kinds of situations so that we're thinking about this is a home that everyone would love to have, but is it really practical that it should pass on to the next generation in its current form, or that, they want it? And these are some of the things that we will talk about and think about as you're doing planning for your heirloom property. So you always have to plan to protect. If you don't do any planning, and we'll talk about a situation in which, a family left the property just outright to their children and didn't do any of this kind of planning ahead of time and what some of the pitfalls are of that. But if you don't have a plan in place, you're going to end up having some potential issues that may not affect you, but certainly are going to affect the next generation. Things like, are there estate costs, estate taxes involved with this property? Here in Massachusetts, we have an estate tax that gets levied when a value of an overall estate is more than $2 million. And without some kind of planning ahead of time, there may be estate taxes that end up being levied against the property. There's also estate administration costs. If you don't have a plan in place ahead of time, like the use of some kind of a trust vehicle, there could be probate costs that come at the time of your death. Things like protecting the property from your costs of long-term care or potential lawsuits in the future. We talk about the killer Ds for particularly our children or the next generation. If they get divorced, if they have debts themselves, if they are disabled or become disabled, and disputes within the family about how things are going to be managed, are all things that really have an impact on the property and what might happen to the property. And protection doesn't just happen. As with anything, you really have to plan ahead and think about all of these things in order to ensure that protection is in place and that your wishes are known and followed. So let's talk about what happens when there's no special planning in place. So you have, let's say, a family in which there are 4 children. Parents have a vacation home. As I said, everything runs really well. Mom and dad are alive and owning the property because they manage all the costs, they manage the decisions about use, etc. But they decide they want to leave this property to their 4 children. Well, leaving a property to children is very different than leaving something like cash or some kind of a financial account to a child or children. With property, it's not as easily dividable. You can't just say, here, I'm giving you a quarter and you a quarter and that type of thing and go off and do what you want with it. Unlike a bank account or a retirement account, those kinds of things, which are, again, much easier to divide among the 4. With a property, you're not able to easily divide those shares and allow the individuals to do with the share whatever they want. So we have to remember that property has its own kind of category of asset, and it is not as easily divided among beneficiaries that you want to name. So let's talk about this, the awkwardness or the issues that come with leaving a home in equal shares to this example of the 4 children. So how do they consider things like usage of the property? Who gets to use it when, and how does that decision get made? How do they determine the management of the property? How are they going to keep it clean? Open the pool each year, put the dock in, all of those kinds of things that might need to be done for a property, as well as maybe handling things like a new roof in the property. What happens if the boiler goes? All of those issues. And when you co-own and you pass the property down to the 4 children without having some kind of plan in place, then each of the children may have an equal share in the property, but again, they may not have equal use of the property. How do you determine how things like utilities are going to be paid for, all the homeowner's insurance, all of the types of issues, all of the expenses and the usage of this property that come into play when you now have multiple owners and not, again, just mom and dad who are making the decisions about what happens with the property. Second homes that become heirloom properties, they require extraordinary cooperation, coordination, and financial attention. A very interesting kind of side story. Again, I own a property up in New Hampshire, and our neighbors actually are a family that of 6 children who inherited the property from their parents. And amazing that for many, many years now, they have been able to manage that property among these 6 families very successfully. And part of it is because they do this kind of planning that I'm going to talk about in terms of agreements around among people. But that can be a place where families can fall apart if you leave a property to multiple beneficiaries and those beneficiaries aren't able to come up with some kind of an agreement about how these things are going to be managed. And remember, it's oftentimes not just your children or the beneficiaries that you might identify. It's their spouses or their significant others. God forbid one of them dies and now their children or their beneficiaries step forward to have an ownership interest. You can quickly go from 4 children to 16 grandchildren, cousins, all of this kind of thing. As the family continues, the property continues to flow down the family line. And so it can become very, unwelding in terms of how you're going to be able to deal with these individuals and how they're going to be able to make decisions. And again, in this day and age, people are very transient in terms of where they're living. You may have somebody who is out in the West Coast and doesn't get to come back and use the property in the same way, and maybe become very resentful that they're carrying costs for a property that they don't get to enjoy and use. The solution that we have come up with respect to how to handle an heirloom property is what we call an heirloom ownership trust. And it's just the name that we put on it and call it a hot trust. And the purpose of this, as with any trust, is to remember that a trust is an agreement. It's something that you put together as the creator of the trust, and you identify typically a trustee. Now, that may be you, and we'll talk about how that works, at least while you're alive, to be able to manage things. But a trustee who's going to be able to make sure that the terms of the trust are fulfilled and that the beneficiaries under the trust are following those terms and gaining the benefit that they are entitled to under the trust. And that trustee can be a family member or it can be multiple family members. I'm not really usually thrilled with having too many people or co-trustees because that can cause its own friction. But naming someone who you trust and someone who you feel will be able to be fair and reliable about how they're managing things, and that they will live up to the terms of the trust that you have laid out. So a trust is something that can be done either, we're going to talk about what's a revocable trust, an irrevocable trust, but a trust is something that you create, that's an agreement that you outline, and you're making an agreement with the person that you name as a trustee to follow your wishes in that trust. So one of the key issues or one of the key components, characteristics of an heirloom ownership trust, a hot trust, is what we call the August term. And this is where we outline specifically the allocation of ownership. Who has what percentage of ownership should this property ever be liquidated? Understanding the purpose of the trust. So laying out why you're putting this trust together, what the intent is with the trust. The governance of the trust. Who are the decision makers? I referenced the family with the 6 children who live next to us and how they manage things, and all of them are married. And one of the things that they agreed to is that there's one vote for each family. So, the child of the original family is the one who has the vote, even though there may be spouses, children, and things like that involved with how a decision is made within that family. It is one vote that comes out in terms of how things are going to be managed. You need to outline how people are going to get to use the property. How do you determine who gets what week? In the summer, there are only X amount of weeks to be able to consider. And how do we make sure that everyone gets some fair usage of the property? Stewardship of the property is extremely important. How are you going to afford or how are you going to lay out how costs are taken care of for this property? Again, real estate taxes, homeowners insurance, maintenance, and big repairs that may need to be done. Anyone who's owned a property knows that if you don't stay up with the repairs and the maintenance on the property will deteriorate. So how do you make sure that that doesn't happen and that there's money to be able to do that? Is it money that you provide with the trust? Is it money that the beneficiaries all need to kick in? These are things that you can determine and decide. And then things like transfer restrictions, possibly in the trust. So, again, you may have four children who are all beneficiaries of this trust, but you don't want necessarily one of those children to be able to go ahead and transfer their interest to anybody that they choose. And so looking at how restrictions may be applied to transferring ownership interest. On the other hand, you may have a child who wants out of the trust and says, look, I'm not using this property. I don't want to be kicking in on the expense of this property, and I want my share of the value of this property out. How does that get determined? So all of these things we look at as we're going through and putting together these August terms so that there is clarity for the next generation as to how things are going to be managed. This preserves relationships between people, sets out expectations, and there's clarity about the usage, clarity about how a share is going to be valued, clarity about how someone can get out if they choose to or need to. So there's a couple of ways we can do this hot trust, this heirloom ownership trust. And one of the things that we look at is maybe that it is the first generation of people, the original owners, let's say mom and dad, they put together what the terms of the August agreement will look like. So they outline how the usage will be. They outline, going backwards, outline the allocation of ownership. They outline the understanding and purpose, the governance, the use of the property, the stewardship, and the transfer restrictions. So they lay that all out from the beginning. So that's one way of approaching this kind of trust. Another way of doing it is saying, look, we're leaving the property to our four children, and here's their option. They can either sell the property right away. They all agree, property gets liquidated, it gets sold, and they all walk away with their share. Number two, one or more of them can buy out the other, and the trust can lay out how that would work. How do you figure out what the value of this property is and what the buyout might look like, and maybe what the time frame for that buyout might be? Another possibility is, look, the four of you want to continue to own the property together. You want to continue to enjoy it. Then you must come up with this August agreement. You need to be able to put out the terms yourself, and you need to agree to that within a certain period of time after the death, let's say, of both parents. And if you don't do that, then you go back to the other two, either sell the property or certain members buy out the others. If you are able to come up with that kind of an agreement, then typically it's done for a period of time. We'll talk a little bit about that. We can look at, they can be anywhere, we talk about as little as 5 years. Now, you could go even year by year, but that can get very, very difficult to have to continually adjust the agreement. So anywhere from 5 years to 99 years, whatever you would like, or, to have that agreement go on, they can put that together for whatever period of time they feel is appropriate, and then revisit its terms as needed. And then the generations, you can decide, is this just going to affect one generation, or are you going to be affecting many generations going down the road about how they're going to manage this property? And commonly what we see is anywhere between 5 and 10 years for the renewal options on that agreement. Again, there's a reason for having an agreement that's in place for a period of time. It gives some consistency, everyone can understand what their responsibilities are going to be under the agreement, what their usage of the property is going to be, et cetera, and can plan. If you're changing it up every year or two, it can start to get very, very difficult on everybody. What happens this year, I can't plan ahead for when my vacation will be because I don't know what the agreement is going to be. And again, it can be for as many years of ownership that the individuals may want. We always do want to make sure in any agreement, though, that we have an out clause. And really, that out clause is about how you buy out other individuals, because life changes, things happen for people. And maybe the four children, again, originally thought they all would love to use this house, but one of them ends up taking a job somewhere on the West Coast or abroad or whatever. Or maybe they get to a point where they say, you know what, I'd like to have my own home. I don't want to continue to own it with everyone else, and I want to be able to pull my value out of this. So figuring out what a buyout structure would be for that is very, very important in terms of how the trust is put together. What if somebody wants out? How do you do that? You can do it by saying, okay, if somebody wants out, then you get a fair market value for that property, and they must go ahead and buy out their share from the others based on that fair market value. You could set a price. This becomes a little bit more difficult, particularly with property values increasing so dramatically over the years. But if you chose to want to set that price ahead of time, you can do so, and say this is what the buyout would look like, and this is the value that the individual would get if they chose to sell their share. You may want to provide some kind of funding for the trust so that you can keep the property. So possibly, and I'll talk a little bit about something like the use of a life insurance policy that could be used to fund this kind of trust for a couple purposes. One is certainly to provide a pool of money to keep the property going, property taxes, maintenance, that type of thing, homeowners insurance. Another possibility is to have this fund so that if somebody does want out, there are funds available to be able to be used by the others to buy their share out. And it makes it so that people are not having to somehow scramble into their own pockets to be able to figure out how to buy out the individual who wants to leave. Then you can have what we call it the take it or leave it, which is, look, this is what the value is. You either decide that you're going to buy out the other individual. So let's say of the 4 children, one of them wants out. And the price has been set, or there has been, let's determine what fair market value is for this. And the other 3 say, you know what, we just can't. We can't buy you out. We can't come up with the money. Well, in that case, then the property has to be sold. If one wants out, then and the others are not willing to buy them out, then the property gets sold and everybody has to get out. So there are ways to be able to think about all of these things ahead of time, and it takes some time. You've really got to run through some of the different options. And everyone's families are a little bit different, but there are some real commonalities that come across for everyone, because there will always be somebody who is not able to use the property in the same way as the others. There'll always be somebody who cannot afford to pay the cost of maintaining the property, or somebody who wants out and wants their share to be able to do something else with. So you want to be thinking about all of these things ahead of time and making sure that you've got as much of this thought through as possible in order to keep, again, really the family relationships going. There is nothing worse than having something like this wonderful family home that everyone loved to go to become the reason that the family becomes fractured in the future, because somebody somehow feels that they're not getting their share. So let me talk quickly about a case study. Again, I'm going to go to this family. Mom and dad bought this house. It's a vacation home down in the Cape. They paid $200,000 for it back in the day. Now it's grown to $2.2 million. Kind of hard to believe, but certainly something that we do see happening frequently. We have a couple of things we have to think about. In Massachusetts, particularly if the property is located and the individual is a Massachusetts resident and they pass away, we may have an estate tax issue that comes up. And again, this is a very, very general example, but if there's an estate over $2 million, and in this case, the estate's worth $2.2 million to get all together, then there's going to be about a $200,000 value that's subject to the estate tax. And that can be about 10% or $20,000. So how do we end up having to pay that and to deal with that kind of tax? And we need to make sure that there's also monies, whether it's coming from the beneficiaries themselves or whether there's money provided in the trust to pay things like the estate tax, regular real estate taxes, mortgage, if there is a mortgage on the property, homeowners insurance, all of the things that go with the upkeep of the property. So if this property was not planned for, and after mom and dad passed away, it passed through probate and went to the four beneficiaries, some of the things you have to think about is number one, there's cost of administration of the estate. And depending on the size of the estate and the complexity of what we might be dealing with, you could have fees that could be anywhere between $10,000 and $40,000. So, there's cost associated with probate itself. Then this property would be passing to the four children as equal owners, each of them having a 1/4 share. Again, no plan put in place that says how they're going to manage this property. And God forbid one of the children then dies before any kind of planning is done. Their share is going to go through their estate. And now you may have even additional owners added to this complex situation. And there's no provision, no thought about how the management of this property is going to happen. We also, in this particular case study, have a couple of other issues. We've got two kids who want to keep the property and two kids who don't. And then we also have a child who might be going through a divorce and another who has a tremendous amount of debt. In this case, you may end up with a situation in which, particularly for the divorce and the one who has a debt, in which this property is now viewed as an asset of theirs, or at least a portion of an asset of theirs, and it might be reachable by their creditors. It might be reachable through some kind of a divorce action in terms of the ex-spouse getting to have some kind of ownership interest or value out of the property. And this is where planning can be very helpful, because thinking about these issues ahead of time, the trust can help to really address how these situations might be dealt with. And then what can be done to prepare to keep the property? So if, let's say, mom and dad in this case did not do any planning, this would be something now where the kids could step forward and potentially put some kind of an agreement, some kind of a trust together that they create, and go ahead and address those August issues that we talked about. So they have an agreement in place to be able to make sure that the ongoing management of the property is dealt with. So what if mom and dad came in and said, you know what, we do want to deal with this issue ahead of time. We want to make sure that our four children are going to be able to inherit this property, and we want to make sure that they do so in such a way that it's not going to ruin our family, that there's equity in terms of how the property is used and who's paying for what and all of that. So this is where we use some kind of a trust agreement, and we put a trust in place. And the trust can be one of two types of trust. It can be a revocable or revocable trust. We also call them living trusts. Or it can be an irrevocable or irrevocable trust. And the difference is really the control that someone has over the trust. So in a revocable trust situation, mom and dad put the trust together. They're going to have control over that trust during their life. The property is still under their management and their control. They can change the terms of the trust if they want to. So they're able to go ahead and have as much control over this property as they choose. They can go ahead and put those August terms together if they wanted to. So put the agreement expectations together in the revocable trust, or they can leave it so that the children need to create it after they inherit the property within a certain period of time. But they can lay out what the expectations are with respect to that August agreement. They might want to, in the revocable or the irrevocable, they might want to be able to put some kind of asset in it, like a life insurance policy, to help make sure there's liquidity in the trust to be able to pay for expenses that may come up. Or they could say, look, this is something where the kids have to all pony up money of their own. And this is part of the agreement, the August agreement that's going to be put together about how things are going to be paid for and how decisions are going to be made about things like maintenance, things like improvements to the property. Do they put in a brand new kitchen, or do they live with the one that's there? How do you go about making those decisions? That's all determined by the August agreement. And there are other sources, of course, that can be dealt with in terms of funding the trust, utilizing retirement plans, other portfolio assets that may be there. So those things can be used with the revocable trust to be able to fund. So I gave a little diagram, so staying on the revocable trust situation. Again, it's one that In this case, I use the example of a husband and wife, but it can be an individual as well who owns the revocable trust. They're the ones who retain the control over the property, and they continue to have the full use of it, including the ability to be able to change the terms of the trust if they chose to. And then, after the death of the original trust creators, then either they have created in the trust the August language, or they have the children go ahead and do that. And so they may want it so that they leave it up to the beneficiaries themselves to come out to how the agreement's going to look and for how long that agreement will be in place. And you may want to use some other type of vehicle like an irrevocable trust to be able to hold something like a life insurance policy that will fund the revocable trust to make sure that there's money there to be able to be used. And so there's lots of ways to create trust and trust language to make sure it's meeting your goals, whatever that might be. Now, one thing that's not here is the use of the irrevocable trust. And this is where mom and dad might transfer that property to an irrevocable trust situation. And this is one that's often used to protect that property so that if something happens to mom and dad during their life and they needed something like long-term care, the value of that property would not be subject to being spent down on that care. So it's a way of protecting the heirloom property from being spent on mom and dad's needs. The other thing that can be done in the irrevocable trust, again, very much like the revocable one, is now mom and dad can decide how is that property going to get managed when they're no longer here. Will that be something that mom and dad create? They put the August language into the irrevocable trust, or will they leave it up to the children once again in order to be able to set up that agreement themselves? So the first thing you have to decide is, do you want control as the owner of that property? Do you want control during your lifetime, which means that it may be exposed to your needs like long-term care in the future? Or do you want to protect that value of that property so that it is not exposed to your long-term care needs, but you give up a certain aspect of control? So need to decide first what type of trust, revocable or irrevocable, and then determine who's going to make the decisions about how the property is going to be managed in the future. Will it be the original owners of the property who make those August terms? Or will it be something that the owners say the next generation will make and they have a certain time frame to put that in place? So things that need to be considered, once again, is how does an heir buy out others if there is a desire for someone to get out of the property? They just don't use it anymore. They don't want it. They want their value instead. How are estate taxes going to be handled? You know, the last thing we want to see is that a property is going to be left to the children, but that property in and of itself is going to cause an estate tax to be levied against the individual's estate, and there's no money elsewhere to be able to pay that estate tax. Well, then the kids are either going to have to go in their own pockets to pick out the money, or they're going to have to sell the property, which defeated the whole purpose of wanting to put this property into some kind of a trust situation. And it's really a way, you know, in terms of putting together these hot trusts, it's a way of trying to figure out how to pay it forward, how to make sure that the next generation is set up to succeed in owning this property and managing this property together, and not setting them up for some situation of failure where somebody, again, wants out, they can't afford it, resentment builds up, they want their share. And all of these things, again, can destroy a family, which was never the intent with this beautiful vacation home that had all of these memories and all of these desires around it. And now it's become the thing that has fractured the family. So thinking about all of these issues ahead of time is critical. Going through a very clear kind of point by point as to what's important to you, how you want to see things managed. Do you want to retain the control and ownership of this property, including the use of its value during your lifetime? Or do you want to protect it from things like your long-term care costs? And then how do you set up the next generation to make sure that they're successful in managing this property if the desire is that it will go on within the family. So I don't know if there's any questions, but happy to take them. Well, I hope that was helpful to everybody. Again, I think what I'd like everyone to walk away with is that when you own an heirloom property, and again, whatever that property might be to you, it can be your primary home, it can be a vacation home, it can be a rental income, whatever that property might be, you want to really think about what the intent is with that property after you're no longer here and you're not owning it anymore and controlling it. Do you want this to pass on to the next generation? Put in place a plan to make sure that that passing on really has an ability to succeed and doesn't become the point that fractures the next generation.
So I see we do have a question. The question is, if you put the property in a trust, what happens to the cost basis of the house? And then underneath it says, do the beneficiaries receive a stepped up basis at the owner's death?
So great question. It depends on the type of trust that we use. So we have options, and this becomes one of the decision-making points when we're putting together a trust. If we continue to have the value of that trust be part of the trust creator's estate when they die, then there'll be a step up in tax basis. But the value of that property may be subject to the estate tax, particularly if it's located here in Massachusetts and the individual is a Massachusetts resident at the time of their death. So we have to look at these different things. Now, if you decided you did not want to have that property as part of your estate from the estate tax calculation, then you may lose the step up in tax basis when you put it in the trust. Well, wonderful. Thank you, everybody, for participating today. It was really great. And if you have any further questions about this issue, give us a call.